Hi all, welcome back to my YouTube channel. So in today's video I'm going to discuss the remaining part of the preamble of our Indian Constitution. Actually I have made two videos before this YouTube video that was explaining what is preamble and what is the objectives of the preambles. Okay, I've discussed everything in detail about that. If those who want to check it out, those videos, you can go to the description, or I will post it in like the I button. It's on the top of the video, and you can watch it, those videos, and you come back here so that you will get a clarification. So let's jump into the video right now. So I'm using my not a teleprompter like that. I'm using a screen over this behind this camera, behind this smartphone. So I'm going to slide all those things, the notes, then I will read out and then I will explain. Okay, so in today's video I'm going to, as I said, the status of the preamble. Status of the preamble. Status of the preamble means what? What is the current status of the preamble? That means, like when I was explaining what is preamble and what's the objective of the preamble, I clearly mentioned a word called as not enforceable in any court of justice. Like that, you know, our Supreme Court, our court judiciary structure, that is starting from the Supreme Court, the apex court, then comes down the high courts, and then comes the district courts, and then the different appellates or different courts having different jurisdictions and different objectives. But who can apply to a court? Who can apply when I had any kind of problems with my fundamental rights, when I was teacher, when I was exploited, when I was into some kind of criminal acts, whatever, criminal or civil or anything, I can approach the court. But on the basis of what? We have something called as law, procedure established by the law. That means what? There is a parliament, and in this country there is state legislative assembly. Each of the respective department legislative assemblies, they pass laws. So if that law is there, if that law is not enforced properly, then only we can approach the court, because that is the document, that is the mandate. Okay, that is the bedrock, we can say. The law is the procedure established by the law, is the bedrock of the judiciary. Okay, if there is no law, I don't know, is there in such cases? I don't know about that. It's completely in law and legality terms. And for just layman understanding, what I'm trying to say is beyond the laws, beyond the acts, beyond the recognitions, or beyond the assent of the President of India. If there is such things, such a dispute happens, what we can do? We cannot do anything. You understood? So, but if you take our constitutions, our entire system, each and every law has some kind of violation, and it is not enforced properly, we can approach the court. But in the preamble, in the constitution, it's one of the supreme law of this land and the supreme document of this country. The certain section that is called the front page, the preamble, is not enforceable in any court. That means what? If preamble is just giving you what is the idea of India, but it is not enforced in any court, means that you cannot challenge any of the government, any of the policies, any of the authorities, any of the state, any of the government, by like they are not enforcing the things what is ensured in the constitution, like it is secularism or democracy, republic. That doesn't mean that a country is not going to be undemocratic. No, it is not like that. The meaning is not like that. The meaning is like that. Okay, it is written like that. Why this country is running like this? Like that, you cannot file, like officially cannot file any kind of a case or an application in any of the court. So that is called as not enforceable in nature. That means so what I'm trying to say is that how this became like this, why this page of this document is not enforceable, and all other acts, all other like amendments, all other constitutional articles are justiciable in nature or enforceable in nature. Okay, so let's get into the deep of it. Okay, so I will read out. Okay, so the preamble, being part of the constitution, is discussed several times in the Supreme Court. It can be understood by reading the following two cases. Like as I gave you just an introduction like that. This is an introduction brief, but in our judiciary, in our system, it is already discussed decades. Okay, not just minutes or hours, it's decades. Experts, okay, they have already discussed everything. So through that, and those cases, some cases will happen. So what are those cases? Okay, and that leads to the enforceability of justiciability of the preamble. Okay, the first case called as Beruberi case. If you are in the UPSC circle, if you are in any of the government exams circle, if you are in particular to the Indian polity or any other subjects, then you will be aware of the subject. Okay, the first thing is called as the Berberry case. What is meant by Berberry case? It was used as a reference under Article 143 of 1 the Constitution, which was one of the implementation of Indo-Pakistan Agreement related to the Berberry Union and the exchange enclaves which were decided to consideration by the bench consisting of 8 judges. I believe it's related to some kind, I don't know the exact history of this, but the Berberry case is related to the exchange of enclaves, that is India and the Pakistan. That is India-Pakistan means that the Bangladesh, not the actual Pakistan right now, the then Pakistan, the East and West Pakistan, so the East Pakistan, the then East Pakistan now is called as Bangladesh. So while exchanging some enclaves, maybe through wars, maybe through some kind of like treaty, or I don't know the exact history about that, but anyway, regarding that case, only the Supreme Court or the courts came into a conclusion that is related to the preamble of the Constitution. Through the Berberry case, the court stated that the preamble is the key to open the mind of the makers, but it cannot be considered as part of the Constitution. Therefore, it is not enforceable in any court of law. So, while giving the judgment of the case, while giving the judgment of which was on the implementation, it referred that it says that the court says that this is the preamble of the Constitution is considered as the preamble is the key to the open the mind of the makers, but it cannot be considered as part of the Constitution. Maybe actually this case is not related to like if you see the judges, if you see the judgments, or if you see the cases history of India, it does not directly attacks or directly confronts the articles of the Constitution, but it gives some kind of a alignment, some kind of a just a reference. So this is just a reference. In Berberry case, the judgment came in like this, and it is stated clearly that preamble is the key to open the mind of the makers, but it is not considered as part of the Constitution. That's all. That was the first case. So through this case, after the final verdict of the Berberry case, the Supreme Court, the courts became into a conclusion that the preamble cannot be what not is justiciable in nature. Okay, next we have another case that is also a famous case, and this case is been mentioned recently by the Vice President of India, that is called as Keshwan Bharati case. I believe Jagdeep Dhankhar made a remarks on the constitutional the values in the Constitution, and there are some words which was added to the Constitution in the 42nd Amendment of Act of 1976 during the the regime of Prime Minister Indira Gandhi. So in that case, that was the case. Okay, the Keshwan Bharati case. In this case, for the first time, a bench of 13 judges was assembled to hear the writ petition. The court held that. What is meant by writ? Okay, so here writ means like when you lose the constitutional fundamental rights, maybe like in a particular language it is written like that. It is mentioned. It is called in several names. Okay, so fundamental rights, we all know that from basics of our classrooms we have learned what's our fundamental rights. That is right to freedom, right to equality, right to education, right to cultural and minority rights, right against exploitation. Like so many six fundamental rights are there. Basically 6 fundamental rights, and it expands. Okay. Sorry for that. So the 6 fundamental rights, when I lose my 6 fundamental right, I believe that it was attacked by some other. So where I can go to the court, right? So how I can go? By filing a writ. That is called as writ. That is the name which is called as writ for against losing my fundamental rights. Regarding the fundamental rights, when you file an application, that application is called as writ petition, or that is called as writ. Okay, simply writ. So in that case, the 13 judges case is clearly unanimously decided that the preamble of the Constitution will now be considered as part of the Constitution if the preamble is not the supreme power or source of any restriction or prohibition, but it plays an important role in the interpretation of statutes and provisions of the Constitution. So it again argumented that it does not have any kind of supreme power. It does not source any kind of a power to enforce something. It cannot be challenged in any court. It clearly says that it plays an important role in the interpretation of statutes and provisions of the Constitution. Like what is, as I said already, what is this Constitution? How you should interpret, how you should understand, how you should define, how you should describe, how you should explain everything. How the basic, the common the objective of the constitution is clearly understood by reading the preamble. If a person want to understand the constitution of India, the country itself as a whole, he can read the preamble and he can realize, oh, this country is like this country forecast, this country is put forward freedom, right to liberty, equality, fraternity, or secularism, or democracy, republic, whatever. Okay, so this is called as the preamble, and this preamble is not the supreme source of the power, and however it is also not part of the constitution. That is the exciting part here. That's one of the interesting part. It is not part of the constitution. So like that it is said. Okay, so it can be concluded that the preamble is part of the introductory part of the constitution. Okay, that means like constitution, while implementing the initializing the constitution, it was part of the inserted into the introductory part of the constitution. That's all. And in this case, it is the major thing is that, of course, again it validated that it does not have any justice enforceability in court. The second thing is that it is not at all will now be considered as part of the constitution. It's part of the constitution. It is part of the constitution, but it is not having any kind of enforceability. That's the second point. And in the third case, that is also a very important case, that is in the LIC case, or Life Insurance Corporation of India versus the government of India. In 1995 they had a case. Okay, in the what was the cause, I don't know. Anyway, in that case the judgment came like this. Okay, and the Supreme Court also once again held that the preamble is the integral part of the constitution, but it's not directly enforceable in any court of the justice in India. So that means, so in all these three cases, actually all these three, the important factor that you have to see in this article, in this video, in this topic, is that preamble is directly been challenged, or the Supreme Courts or any of the courts in this country does not give a direct argument or direct agreement or direct enactment or any kind of like interpretation regarding the essence of the preamble. But through several cases, while discussing those cases, while passing out the judgments, while doing the hearings, they may refer the preamble. Maybe the advocates, or when doing any kind of like discussions, they may refer. So while depending upon the reference they have made, the advocates made, maybe the court judges may pass such comments on the judgments, and that's how through these judgments we came into conclusion that preamble is not part of the constitution. Okay, first thing, preamble is part of the constitution, but it is not enforceable in any court of justice that is in Indian territory. So in the 1995 case, it again validated, it again gave some kind of a strength to the point that it is not enforceable in any court of the law. So that is the status of our preamble. And in three cases, nothing but important is that important thing is nothing but through three cases, the court came into the conclusion, or our system came into the conclusion, preamble is just a tool or a paper or a page that realizes what is this country is. But of course it gives you some kind of a forecasting like objective to the politicians or the people who run this country. Okay, but it is not enforceable in any court of the law. So that's the 3 points. And the second point is the second part of the video is the amendments of the preamble, and we discuss in the second video. So hope you stick on to the series, so you will understand more better. Okay, so thank you for watching my YouTube channel, and if you find this really helpful, subscribe, share, hit the bell button, and what all things you can do all those things, and let me know what's your thoughts on this, okay, about this video and the content like that. Okay.